Okay, so thank you very much. I want to begin this presentation, as I promised Raphael, by embarrassing Raphael. And I think this is very due because this is the best conference I've been to in a very long time, maybe ever. So I think this goes to the credit of Raphael, but of course to Sean, Eva, and the whole team, and of course the funder, for making this amazing conference happen. So we are so happy. Yeah, there you go. I can see him blushing, and Sean is also a bit red, but I'm not sure whether that's because of lunch or something. Anyway, I'm going to be talking about a book which Raphael failed to mention. He's also writing, at least he's supposed to. And we are writing this book together on animals in constitutional theory called Animals and the Constitution. It's great. Great title. But it has a subtitle which is Towards Sentient-Based Constitutionalism. And today, in the next 20 minutes or so, I'll be talking about a chapter in the book and giving you a kind of broad stroke picture of the book. And this chapter is our constitutional rights chapter. Okay, so the book is situated in constitutional theory and so tries to paint a picture of an ideal constitution. So a constitution where of course, humans are adequately protected and their basic interests are adequately protected, but also sentient animals, right, are also protected, adequately protected. Their basic interests, their fundamental interests, form part of the constitutional tradition. And what does this mean then for constitutional principles? This is what the book tries to spell out. What about principles such as the rule of law, of course constitutional rights, which I shall talk about today, but democracy, proportionality. So we try to spell out all of these principles in the book, and as I said, today I'll be focusing on constitutional rights chapter. So the basic theme of the chapter is actually quite conservative thing, right? The basic idea is quite a conservative one, and it goes something like this. Now, in a what we call the sentience-based constitution, well, because it's a mouthful, I'll just call it in this ideal constitution. What would constitutional rights look like? And this seems to be a pressing question because both through judicial means, as we have heard yesterday and today, but also through legislative means, people are trying to introduce new fundamental rights in constitutional documents, right? So, of course, Eileen gave us a good overview of some welfare provisions, but we'll hear more about the finished proposals that tries to guarantee rights, fundamental rights for animals, and as a sort of different categorization, it needs a new amendment. It proposes certain rights for wild animals, certain rights for domesticated animals, etc. And of course, this follows from previous attempts to introduce new chapters in the Constitution, new constitutional amendments, such as in Spain, where great apes, are trying to, there are new clauses that are being attempted to insert in the Constitution. Of course, the Swiss attempt in the canton of Basel, unfortunately that failed, but that was supposed to change the Constitution in order to introduce a right to life, integrity for apes. So, there are these proposals. Of course, I won't talk about the recognition of constitutional rights to the rights of nature in Ecuador and in other places, because we have heard from real authorities about that, so I won't speak about that. But there's this concern that we need to introduce, at least in these legislative proposals, new documents, right? Because animal rights is a new thing, so we need to do that. But we are a little conservative in this chapter, and our basic thesis is we don't need new chapters. Right? Existing catalogues of rights protect the various interests and capacities that animals have, because following from what Manisha and I were briefly discussing, that humans are animals too, right? And so many of the basic interests and capacities overlap, and given certain features of constitutionalism, we don't necessarily need new amendments in order to protect the basic rights. So it's conservative to the extent that, we can do with existing Bill of Rights. Of course, as a good scholar, you should put a couple of provisos and exceptions, and I will do just that. One of them is that, of course, there are certain catalogues of rights, such as in Australia, that are so brief, right? And they don't even cover many of the fundamental interests that humans are used to. And so, of course, in such a constitution, one would need additional rights to protect both humans and non-human animals. And the second proviso is to disclaim any sort of criticism of, though some will be inherent, but in general, no sort of criticism for these legislative proposals, because we understand where they're coming from. They come from a place of pragmatic policy making, right? So remember that we, and by we I mean Raphael and I, are talking ideal theory, and so we don't have to struggle with the day-to-day politics and the pragmatic operations, right? So, of course, there may be very good pragmatic reasons for having clear constitutional amendments to protect animals. And so, in theory, we don't object to that, but in practice, we don't object to that. But this grand principle is that we can have this, we don't need them, at least in a animal-respecting constitution. Okay, so a little bit about methodology that will help us substantiate this claim. So as I said several times, this is an ideal constitution, so it's a theoretical endeavor that we have, but our ideas are not plucked out of nowhere, right? And so we want to ground the ideas and our claims on actual practice in non-ideal constitution, especially the practice of constitutional rights. In this chapter, we interpret constitutional rights a bit more generously, so we include fundamental rights in international documents like the European Court of Human Rights and the Inter-American Court, but with special focus on the ECHR, the European Convention on Human Rights. And so we want to pick certain features of practice to ground our claim, but because it's a theoretical endeavor, we need to justify those features of the practice that we pick out, right? And so we have a sort of Rawlsian reflective equilibrium between the practice as it is, right, that informs some of our choices, but also moral justification for our views. So yes, I said Rawlsian reflective equilibrium, but also I could have talked about Dworkinian methodology as well. Okay, so what are these features of the practice of constitutional rights that inform our very conservative view that, in theory, we don't need new chapters of fundamental rights to defend animals? And I have 4 of them. We pick out 4 of them. The first is progressive expansionism of the subject of rights that is inherent in the practice of constitutional rights. The second one is the non-hierarchical nature of the subjects of constitutional rights. The third one is the over-inclusiveness of ways in which constitutional rights are formulated, and to follow from that, the generality in which they are formulated. So these, which I'm going to explain them in the next few minutes, all of these features of the practice of constitutional rights inform our view and help us defend our view that in theory we need not a new Bill of Rights, a separate Bill of Rights for animals. So let's go through each of them in point and with examples from constitutional practice. So in terms of progressive expansionism, what do we mean by that? We mean by that the subjects of rights, of constitutional rights, have historically been evolving. So we talk in moral theory of the moral circle, okay, of rights holders, but we could make an analogy to constitutional law and constitutional theory, that the subject of constitutional law, the moral circle or the constitutional circle expands over time. Take the right to vote in the US Constitution, for example. There was a prerogative of white men who owned property, and over time extended to white men who didn't own property, and then Native Americans, Black American, or men, and then women were added. And over time, people that are incarcerated, some states allow for them to vote, and some states nowadays are also pushing for decreasing voting age. Right, so from adults over 18 to under 18. So over time, certain the subjects of constitutional rights have been expanded, and this is inherent, not just of course in this example that I've given, but in other features of the practice of constitutional rights. What does that mean? It means that the category of who can be protected by standard constitutional rights, such as the right to vote, but also freedom, liberty, etc., has been expanding, and has been expanding beyond the human. So one very clear example is that corporations have human rights, churches have human rights. Yes, I see some skeptical looks, but if you consider the jurisprudence of the European Court of Human Rights, that protects fundamental rights, but also, of course, protects human rights. But also the domestic jurisprudence in the UK, for example, many corporations and churches, of course, have the right to freedom of religion. You may have heard of the gay cases over different parts of the Atlantic, whereby corporations owned by Christians, usually evangelical Christians, did not want to serve gay couple, and these corporations benefit from the right to free speech and from the right from compelled speech, and the US Supreme Court recently in 303 Creative, but also the UK Supreme Court in the Asher's Baking case, found that these rights actually can trump human rights, right? The rights of these corporations can trump human rights. And the same, the European Court of Human Rights and the European Commission on Human Rights also found that certain corporate rights can actually trump basic human rights, okay? And that these rights are recognized as part of the Constitution. So, of course, the counter-argument here is to say that these rights, these corporate rights, they are just a legal vehicle to protect humans, right? So they are really human rights. So they are the corporations are just instruments to protect human rights, and this may well be so. But that still reiterates the point that the existing catalogues of rights, such as the European Convention on Human Rights, or rights that we enjoy in the UK, in the US, and many others, have over time been expanding to cover all sorts of entities. So in a constitution, in our ideal constitution, a sentience-based constitution, that actually takes seriously the interests of animals. Based on this practice, elements of the practice, there's nothing in principle that stops existing rights catalogues to be extended to animals. Okay, so that's the first feature. I'll try to go a bit quicker in the others. So the first feature was progressive expansionism of rights, but there's also the idea of non-hierarchical status of the subjects of rights, some of which I've alluded to already. So what does that mean? It means that constitutional practice recognizes that no one constitutional subject has necessarily superior rights to another kind of constitutional subject. Clear example that I've already given is that there are several human rights recognized in constitutions, but there are also so-called human rights or fundamental rights of corporate bodies, churches, institutions, and so forth. And that when there is a clash between these various constitutional subjects, it is not that one constitutional subject has an automatic trump card to win. So corporate rights, or the fundamental rights of corporations or of churches, sometimes trump human rights, okay? Or the fundamental rights of humans, and I've given examples already to that effect. So what does that mean? Is that it means that in a constitution respecting, in an animal respecting constitution, the ways in which rights are structured can reflect this non-hierarchical notion that constitutional practice already has. What does this mean in practice? It means two things. One is that there should be no hierarchy between humans and animals in a constitution, in an animal respecting constitutions. That is, that the rights of humans should not automatically be held to trump that of animals, and vice versa, of course. But it also means that certain endeavors to recognize only certain animals fail to conform to this ideal of the ideal constitution. So we've heard about how in Ecuador, for example, certain rights are recognized only for a category of animals, like wild animals, and the Finnish proposal that we'll hear much more about differentiates between different kinds of animals and apportions more rights to domestic animals, rather, that's my understanding, but you will correct me, than to wild animals. So the Ecuadorian practice go in one direction of affording more rights to wild animals, and the Finnish legislative proposal goes the other way by affording more rights to domesticated animals. So in an ideal constitution, would go neither way. Yes. So under the ideal constitution, all constitutional subjects would have entitled to equal rights. Of course, we need to put some caveats to this. We recognize that historical injustice sometimes mean that constitutions needs to give special protections to categories of constitutional subjects. So take the Indian example, where the constitution affords specific rights to, for example, women, and reserves some quotas in the political participation process to women, giving histories of injustice and sexism in the Indian context. And we can recognize that certain constitutional rights are specific to particular subjects. So, for example, a constitutional right to abortion will only apply to certain women, people that can actually be pregnant, etc. But recognizing that there are particular clauses that are specific to particular categories doesn't mean that we need to have a hierarchical status between different constitutional subjects. And in fact, in an ideal constitution, there will be no such hierarchy. Okay, so briefly in the last 5 minutes or so that I have, we have two more principles of constitutional rights practice that informs our conservative view. To remind you, the conservative view is that we don't need, in theory, new constitutional documents to protect animals. But there are some worries, right? Because animals, yes, we are all animals in one way or the other, but that doesn't mean that we are all the same. There are different interests, different capacities at play. And in some cases, as we were reminded yesterday, I think, in the Ecuadorian context, new animals are being discovered. Not developed, yes, though they are also being developed. But new animals are being discovered every year, yes. So the interest and capacities that they may have, we cannot necessarily predict them because we don't know what they are. So how would a constitution, the ideal constitution, reflect this? And what does constitutional practice has to say about this problem of animal diversity? One, well, constitutional practice shows that constitutional rights are over-inclusive, but they are also general. And these two features help us manage this problem of let's say, animal pluralism. Yes. So by over-inclusive is the notion that not all rights that exist in constitutions apply to all constitutional subjects. So I've already given the example of the right to vote, but also the right to abortion. Right. Only certain people that have the necessary capacities to for example, vote or to be pregnant have benefit from this right. This, of course, doesn't mean that there's a hierarchy between constitutional subjects, but it kind of mitigates the worry that having a conservative Bill of Rights won't be able to adequately cater to the animal diversity, right? Because of this over-inclusive factor. But the second thing that can mitigate this worry of adequately protecting the diversity of the animal species is the generality of constitutional rights, which is the final feature that I will be talking about. And the generality means that rights are formulated in a very high level of abstraction. So we talked about the right to health, but then this general abstraction needs to then be concretized, usually through judicial or legislative specification. And take, for example, the right to health in the India Constitution and the Bombay High Court finding that this right to health entailed the right to sanitation, a right to a toilet, right? A very specified right, especially for women in rural areas of India. So what does this have to do with our conservative thesis? It helps us address this problem of animal diversity, that the fact that we don't know what interests, or we may not know, or there's such a diversity of interests between animals, is compensated for by the fact that that constitutional rights are so general that they can then be specified, taking into account the necessary interests and capacities that, individual animals have. So in this sense, this helps reinforce that critique of the Ecuadorian and Finnish proposal of differentiating between various categories of animals, because by the generality that constitutional rights have, through specification, we can be open to accommodating the various interests. Final proviso, of course, because we don't have good knowledge of all animals, we should be open to the fact that in some exceptional circumstances, if there's a new species that has interests or capacities that go beyond our comprehension, then in a constitution, an ideal constitution, we may need to add extra rights to cater specifically for that. So that's how we may need to be a bit more progressive than conservative. Okay, so the chapter then has a section where we show how existing constitutional rights, bear in mind these 4 principles, can be extended to animals, and we talk about the right to life, the right to physical integrity, physical and mental integrity, and the right to freedom. And we show how an ideal constitution would expand these rights and apply them to animals. But because I've run out of time, you are welcome to ask for a copy of the paper and read that. Thank you very much.